Alright, welcome into the video lecture on Chapter 11. This chapter focuses on the Sixth Amendment and the right to counsel and a fair trial. So the Sixth Amendment has multiple discrete clauses in it. One is the speedy and public trial requirement. So Sixth Amendment requires speedy and public trials and delays that in the trial process that results in the defendant being unable to present their defense might cause the charges to be dismissed. And this is just kind of under the tenet that it's inherently unfair to let somebody kind of be in limbo of not knowing whether they're going to be convicted or not. So when we were trying to figure out what does it mean for a trial to be speedy, we look at the length of the delay, the reason for the delay, the defendant needs to assert their right to a speedy trial, and the types of harm caused by the delays. Another clause in the Sixth Amendment looks at the requirement for a fair and impartial jury. This means that any crime that involves jail time need to have a jury trial. Petty crimes don't require a jury trial, but any serious offense results in the defendant having the option for a jury trial. As part of a jury trial, voir dire occurs where frequently judges ask the questions of potential jurors to determine if they are biased and if they can be impartial. And each side, generally for felonies, get 8. For death penalty cases, get 20 peremptory challenges. So that's lets each side remove jurors for whatever reason they may wish, as long as it's not discriminatory. And that requirement comes to us from Batson v. Kentucky in 1986. Prosecutors cannot use peremptory challenges to exclude jury members on the grounds of race, and that's been extended to sex and ethnicity as well. Another part of the Sixth Amendment is that it requires the trial to occur in the district where the crime was committed. Now, this is not an absolute. Defendants can make a motion to change venue, and they might do so because they cannot get a fair trial, and another location might be extremely more convenient for everyone else involved in the trial process. Alright, moving along. Our next clause in the Sixth Amendment is that the defendant has the right to be informed of the accusation against them. They need to know what they're being accused of so they can prepare. And then defendants also have the right to confront witnesses against them. This is called a confrontation clause of the Sixth Amendment. So any testimonial statement, this applies to any testimonial statement. A few years ago, there was a movement to make it so that experts who run lab tests do not have to come and testify. They could just prepare a statement. And the Supreme Court struck that down because it violates a defendant's Sixth Amendment rights. As part of the Sixth Amendment, defendants are entitled to compulsory process. We achieve this by letting defendants subpoena witnesses who will testify on their side. Failure to comply with the subpoena could result in time in jail or prison. Now, the most well-known Sixth Amendment right is the right to a counsel. This right extends beyond the trial. So everyone who who might serve time in jail or prison is entitled to legal representation, and defense attorneys have an obligation to kind of zealously represent their clients to make sure that the process is fair and their clients' constitutional rights are met. The basis for the right to counsel comes to us from a case called Powell v. Alabama, sometimes called the Scottsboro Boys case, where these boys were all sentenced to death. Their trials lasted a day, and they didn't have defense counsels. So their convictions were overturned. And then Gideon v. Wainwright, 1963, Florida only permitted attorneys for death penalty cases, and Gideon was just charged with a felony. He tried to represent himself, and he lost, and the Supreme Court responded by guaranteeing him the right to counsel, and that indigent defendants have the right to, accused of felonies have the right to have an attorney. The right was further clarified 9 years later when the court extended the right to an attorney for those accused of a misdemeanor. And so we now know that any crime that could result in prison time, defendants have the right to a lawyer. Now, the right to an attorney isn't just limited to the trial. You have the right to an attorney at any critical stage in the criminal process, which would include investigations, pretrial hearings, and during the trial. So this is any part of the process where the accused's rights might be impacted by the absence of an attorney. So in other words, any time where the case could exit the process with the representation of an attorney is generally going to be a critical stage. So in Messiah v. Indiana v. United States, this clarifies the right to an attorney during the investigation process. And because the defendant did not have his attorney, all of the statements that he made to police officers were determined to be inadmissible. Other pretrial times where defendants have the right to a lawyer is during identification. This usually occurs during either show-ups, lineups, or blind lineups. That you have the right to, defendants have a right to have their attorney present to make sure that all the processes are fair and followed properly. And this is the cases that establish the right to have your right to an attorney there. Now, and the reason why, again, to ensure the rights are protected during that lineup show up, is because witnesses, it's a chance to determine whether the witness is reliable or not at that point in the process, and the lawyer has the opportunity to observe the time between the witness's opportunity to view the defendant, the level of attention that they're paying, things like that. In Moore v. Michigan, 1957, it was established that defendants have the right to have an attorney when they are submitting a guilty plea. Also, the first appeal of right, defendants have the right to an attorney, but they don't have the right to an attorney for any additional appeals along the appellate process or for writs of habeas corpus. We presume that the right to counsel includes someone who's effective, which means that the counsel's conduct, to be ineffective, the counsel's conduct must be so below the prevailing professional norms that the lawyer did not ensure a fair result for their client. And that could be a reason for the defendant to win on an appeal. Now, defendants can waive their right. They can represent themselves pro se. They do need to knowingly and voluntarily relinquish their right to an attorney. When you do waive that right, we call it appearing in court pro se. Before a person can represent themselves, they need to understand that they have the right to an attorney, and they need to waive their Sixth Amendment rights. And they also need to be competent. They need to, if they are incompetent, a court will not permit them to represent themselves. Now, everything that we've talked about up to date applies to adults in adult court. In Re Gault in 1967, the Supreme Court determined that Sixth Amendment rights apply to juveniles, including the right against self-incrimination, the right to receive notice of charges, the right to confront witnesses and cross-examine those witnesses, and the right to an attorney. In that case, Gault was questioned by police officers without permission of his parents or without notifying them. on school property, and he made statements that were incriminating, and the Supreme Court reversed that. Police officers need to be cognizant that juveniles have Sixth Amendment rights, and they need to speak to juveniles in a manner that the juvenile can understand. Now, as far as corrections go, Sixth Amendment lawsuits are not that commonly used for prisoners. The times we do see it is they frequently claim that their right to a speedy trial was violated, or they might be filing a lawsuit against other inmates. And here's a couple of examples of occasions where, or I guess, in Memphis v. Ray, the Supreme Court held that at probation revocation hearings, you have the right to an attorney, and we know that probationers and parolees have constitutional rights to have an attorney on a case-by-case basis at those proceedings. So they might not get the same attorney that represented them during the plea bargain or the trial, but they do have some right to have an attorney present during the revocation hearings, because they might risk being sent back to jail or prison. This chapter in your book is very clear. Several of the constitutional law and action boxes are very relevant and provide good, clear examples of how the Sixth Amendment interacts with the criminal justice system. And then I'd like to also call your attention to the table on page 419, which really just details out the cases that establish when a suspect has a constitutional right to counsel. And you can see that in that box that the most recent case was Missouri v. Fry, 2012, which determined that defendants have the right to have a lawyer during plea bargaining process. So we covered a lot of material here. If you have any questions, feel free to reach out and let me know.